Hi, good afternoon, everyone. This is Rajiv S. Khanna for Immigration.com, the law offices of Rajiv S. Khanna PC. Today is March 20th, 2014. This is a community conference call that we hold every other Thursday. I will be going over the questions people have already posted first. One thing I'll be doing a little differently this time is I might be stopping after a few questions I have already marked and asking people if they have any questions. What I have done is I have looked at some of these questions that I think are frequently asked questions. I am marking them separately and will be presenting these questions as short videos, frequently asked question videos. So I have marked them individually. Each time I hit a frequently asked question marked entry on the blog, I will ask you folks if you have any follow-up questions. Okay, as we go along, you'll figure it out, and at the end of it, if we have time, we'll do new questions. First question, it has been marked as a frequently asked question. J1 waiver to green card through spouse who's on H1B. So Vikram wants to know, I am on H1B with the priority date of 7th February 2011. My wife is on J1 doing her residency with a 2-year home residency requirement. We are hoping that my spouse will find a J1 waiver job and convert to H1 by July 2015. So, if my priority date gets current in late 2015, can I add my spouse to my AOS application? Well, the way it works is, unless she has completed her 3 years of the J1 waiver on H1, unless she has finished those 3 years, she will not be able to apply for adjustment of status. Okay? So the law is, it's an interesting state of affairs. Physicians who are on H1, the 3-year H1 which they get when they try to or when they get to waive the 2-year home residency requirement, they cannot file adjustment of status until those 3 years are completed. That's the current government thinking. However, she can apply once those 3 years are completed, even if your green card is already approved. It's called following to join. That's kind of what she would be doing. We had a case in which a physician actually had to go to India because she could not get a waiver job in USA. So her husband got his green card, like in your case, and then 2 years later she got her green card as following to join and came through consular interview. So your wife will not be able to file with you if her 3 year service is not done, but she can apply later on. Next question from Vikram is, our kids are toddlers and both are US born. Is it possible to get hardship waiver? Hardship waivers are not that easy. They are based upon extreme and exceptional hardship. Just because you have two US children, um, that would at best amount to ordinary hardship. I don't think that's a viable option unless there is something so problematic that children have some health issues, God forbid, that cannot be handled back in your home country. I'm assuming that's India. So I think that's a very long shot. Okay. Uh, Anybody has any follow-up question on these two issues I've discussed? Please press *5 on your phone. Any follow-up questions on this particular issue? I have marked it as a frequently asked question. Let me confirm if you guys can all hear me. Sometimes I worry about that.
The conference is now in conversation mode.
Can everybody hear me, guys?
Yes.
Okay, excellent, excellent, excellent. I just get nervous sometimes.
The conference is now in presentation mode.
Okay, so there are no follow-up questions on this. I'll go on to the next question. Papa123, I am sorry, my knowledge of asylum laws is extremely limited. Our focus is more on non-asylum type cases, so I will not be able to answer your question. Ravi 2014. Now, this question also has been marked as a frequently asked question. He says, I'm from India. I've applied for adjustment of status along with EAD about 10 weeks ago. I-140 was approved under EB1. I've seen some applicants getting their ED and in some cases even green card by this time. Processing center is Nebraska. Based upon our experience, our office's experience, what is the average time to get EAD and green card? It's so difficult to say this, Ravi. There are so many variations. EAD, of course, EAD and advanced parole, they try to get it rolled out within 90 days. And more often than not, they are getting it done within 90 days. Okay. We had a green card approved start to finish, I think in like 90 days. I-140, 485 all included. That's the least time I've seen on EB1, in our office at least. Now, you had some questions about the standard operating procedures on I-485. Your question is, there was a SOP, standard operating procedure document, that is about 10 years old. That is correct. That is what we have seen too. There have been some modifications, amendments to it based upon certain new developments. But I'm not going to be able to throw a whole lot of light on what the procedure is. But typically, what you want to know the most is, why is there so much variation? USCIS does not follow, they very loosely follow the first in, first out rule on adjustment of status applications. Because sometimes it can take a lot of time in getting security clearances, etc. So the processing and adjudication time of each 485 can be widely different. Okay, so you're not going to be able to rely upon the first in, first out kind of rule in AOS applications. What I will do is, I will try to remember, look, we are very, very busy this time of the year because of the H1 filings, plus my schedule tends to stay quite busy. But if I get the time, I'll try to remember, and I will dig up for you, and you can do it yourself as well. I remember there have been some federal court cases, quite a bunch of them actually, in the last few months on adjustment of status. One just came out a couple of weeks ago where somebody's adjustment of status had been delayed, I think several years, and the district court said, no, you have to adjudicate the case. Okay. In each one of these cases, chances are there are more updates on the standard operating procedures. When the case is staged, when does it get adjudicated? I mean, there are so many variations. Sometimes what can happen is you've got a case that has been adjudicated, all done. Then all of a sudden, the priority date slipped back. But Officer 1, who had the same kind of situation, and Officer 2 with the same kind of situation, one got the visa number before the priority date slipped back, the other did not. The one who did not get the visa number, which is, by the way, done through email or fax, when the case is adjudicated, the priority date is current, they'll send a fax or an email to the State Department, that's my understanding, and obtain a visa number. Sometimes you can, one case you've got the visa number, the other you don't. So one case gets approved, the other one slides back into the retrogression. There are too many variations. Security procedures is another variation, as I mentioned. In some cases where there is a hit on the name, one example I would give you is somebody's name is Muhammad Ali. There are so many people with that first and last name that those kind of names can create issues. Not always, but those are some of the examples that I know of. Many years ago, we had sued USCIS in an attempted class action on these 485 delays. I found out a lot of information during those interrogatories during those depositions. We deposed two of the USCIS senior officers to find out about their procedures. So these are things that we discovered over that litigation. That's also almost a decade or so old. So I don't have anything new to add to it, but I will try to get you more recent information. You can find it from lawsuits that have been filed on adjustment of status in federal courts. You may be able to find a lot more information, okay? Sekhar wants to know, Again, this is, oh, by the way, before I go forward, anybody has any question on this issue that I have discussed, please press *5 on your phone. Press *5 on the AOS issues that I've just discussed. Press *5. Okay, so I guess we don't have any questions on this. Shekhar, another entry I have marked as a frequently asked question, needs help on the H1B questions below. He's got an H1 with an employer A, which is good till 2015. B has filed for transfer. Let's say it gets approved this year. Does the petition of employer A remain valid even if B's case got approved? Very clearly, yes. So if you are working for A and employer B has filed for an H1B transfer, just because B got approved, A's approval does not get overruled. That is quite clear. Okay. Second, if after approval with B, after working for a few days, or maybe without working a single day with employer B, he wants to join back employer A, does employer A have to file petition again? This is a lot more complicated. This is my understanding of the law. If you had asked me this question 4 or 5 years ago, I would have said no problem. You can have A, B, C, D, all petitions valid and coexisting, and you could keep jumping from A to B to C, 6 months here, 3 months there. That's not the situation any longer. What has happened is USCIS has said if an employee leaves an employer, the employer is duty bound to inform USCIS and revoke the H1. There's a whole history behind it where they come up with this requirement, because this is not a requirement directly in the regulations. What they rely upon is there is a regulation in 8 CFR, I forgot the section, is it 214? I forgot the section. But the non-immigrant visa section, there's only one section that contains all the non-immigrant visas in the regulations. There is a section that says if you have any substantial change in the employment, and I'll come to this point again further down, somebody has asked a question about when do we have to file an H1B amendment? If I change end clients, do I have to do it? If I change locations, I have to do it. All of that relates to substantial change. Okay? USCIS says if an employee quits an employer, like employer A, then that substantial change, and any substantial change, must be dealt with. And how do you deal with it? For a case where an employee has left, the employer is supposed to contact the USCIS and let them know that they are revoking the case. So if you left A and joined B, A would have to inform USCIS. What if they don't? And you joined B, now can you come back to A? That's gray. I would not be able to clearly tell you that you can. Okay. I don't know any law that very clearly points to one direction or another. It is safe to assume that you cannot come back to A without a transfer back, even if A has not revoked. I mean, that probably is a very conservative reading of the law, but I am conservative. I do not like to take chances with the government. There's a time to be aggressive and there's a time to be conservative. If you are planning, always be conservative. If you are defending or put in a position where your back is against the wall, then you can be as aggressive as you want. But when you're planning, you have choices. So try not to be in a situation where you are working for A, then B does your H1 transfer, then you join B, and now you want to come back to A without doing an H1 retransfer back. Avoid that situation. Your third question is, at a given time, can one have more than one valid petition? And the answer is yes. There is one situation in which this can happen very easily. So let's say you are working for A, B's case gets approved. Transfer is approved. You can still continue working for A and request B to give you X number of days because you are finishing up the project. Up to 60 days is no problem in my view. Beyond that, it becomes a little trickier. But when an employer is accommodating an employee's genuine personal need, they don't run afoul of the laws. And I think you would be able to protect yourself in that case having two valid petitions at the same time. So you're working for A, B's case got approved, but you are delaying joining B. I think you could do that. I don't think that's illegal. Okay. Now I've answered these H1 questions, a whole bunch of them. Anybody has any questions relating to this? Press *5 on your phone. *5. Press *5 if you have any questions related to this issue. I hope your *5 is working, guys. Can somebody, as a favor, just press *5 on your phone? Just one or two people. I want to see if it's working. It's working. Okay, that's it. No more. Now there's a whole bunch of them. All right, please press *5 again, and that way your hands will go down. Press *5 again. 3 gone, 2 gone, 1 gone. Thank you. Thank you very much. Okay, so *5 is working. I'm good. I'm glad to hear that because I worry that maybe you're not getting the information that you need to. Let's go on to the next one. Also, this is also something I have marked as a frequently asked question because there is some tricky issues here. S. Ravs says, applied for, this is a little complicated, so bear with me. Guys, you have to forgive me. I was a little bit, I couldn't read the questions this morning because I had a very busy morning. So I try to do the best I can. I read beforehand just to make sure I don't waste your time. But bear with me if I take a minute or two extra. So here's the story. Applied H-1B transfer from A to B in April 2013 and joined B. Got our RFE, upgraded to premium processing. Also filed change of status from H1B to H4 for her husband. Okay, so she was with A, transferred to B or applied for transfer to B. While the transfer is pending, she also applied for H1B to H4 for husband on October 1st. His previous H1B I-94 expires on October 3rd. Receipt date is October 4th. Now, one thing is, so here's the sequence. You sent the papers out for H4 October 1st, but the receipt date is October 4th. I-94 expires for him on October 3rd. This is crucial. I, in these cases, always tell the government, receipt date is the date, Mr. Government, you actually received the papers. It is not the date you put on the receipt, the fees receipt, because that could be 1 or 2 days delayed. So first thing, S. Ravs, what you got to figure out is, were your papers, H4 papers, actually received by the government before October 3rd? Before October 3rd. If they did, you have a very good argument. And why is this important? This is important because of the 180-day rule. The way it works is, if I get my change of status application over to the government's hands before my I-94 expires, then I have no issue waiting for the adjudication of my application. No unlawful presence is accrued because my case was timely filed. If I do it 1 day after my I-94 expires, now I have a much bigger problem. What's going on is, unlawful presence begins to run on the date my I-94 expires, and just because my application for H4 is pending, it gives me no protection at all. Of course, if the government forgives my out of status, they can give me H4 with an I-94, putting me back in H4 status, but I cannot take that risk because after 180 days, I would be time barred. I would be barred from entering USA for 3 years. Okay, and if I continue to stay here for 1 year and then ultimately my H4 does not get me my change of status, I could be barred for 10 years. So that's the rule. That's the way it works. Okay. Does 180-day rule apply to him as H4 receipt date is after? And the answer I just gave you. You also have to worry about the unlawful presence. Okay. If yes, he has to go for H4 stamping, but my transfer petition is pending in background check. So the problem is she's got an H1B to H1B transfer pending. He needs an H4. Can he go for stamping? I don't think he can. He also cannot stay beyond 180 days from October 3rd. Be careful with that also. Can I move back to company A? I just addressed that issue in a separate frequently asked question today. And I'll give you the summary again. The summary is this. When you move from A to B, A is required by law to revoke the earlier petition. I personally don't think you can go back to A even if they have not revoked your case. Okay? So to me, that would be a little too aggressive. And as I've said before, when I'm planning a case, I'm never aggressive, I'm very conservative. But when I have my back against the wall, then I would of course argue everything. You are in planning stages, I don't think you should consider going back to company A without a retransfer. Okay? Moving back from company B to company A is straightforward, or do I, okay, I already answered that. Will there be any problem with the consulate? I don't think he's going to be able to get his H4 stamping. Do you suggest filing writ of mandamus? Oh my God, no. Writs of mandamus are an entirely new topic. I would have to spend a good 10-15 minutes explaining to you why in many of these cases I never recommend the writ of mandamus. In a nutshell, writ of mandamus is not usually for successful case. It is for adjudication because of delay. So just because you won a writ of mandamus, what you will get is an adjudication. It could be a yes or a no, an approval or a denial. It doesn't mean you'll get an approval. In most cases, of course, sometimes writ of mandamus is directed towards a wrong decision. Okay, but those are difficult cases to win, and government behaves like a petulant child, like a 3-year-old from whom you've taken the candy. It's very sad to say that in many of these mandamus cases, they come back with 50-page RFEs just because they are ticked off that you filed a writ of mandamus. No civilized government and no mature human being should ever be involved in that kind of nonsense. But I've seen that happen, only too frequently. Okay, so writ of mandamus in most cases is not recommended. In some cases, again, when your back is to the wall, you may not have a choice. What should you do? I think contacting your congressman might be a better idea. Let's use persuasive methods rather than coercive methods. And explain to them, we've got this, we are a family, my husband is here, I don't want him to have to leave, and can you please contact the government on our behalf and get the H1 moving and also the H4 adjudicated. Maybe that would work. Okay. One more thing I would say is make sure that your H4 is connected to your premium processing, because interestingly, there is no premium processing of H4. But when an H1 is premium processed, you can piggyback the H4 also on that premium process. Just make sure they're connected. Okay? Anyone has any questions on this topic that I've just discussed, press *5. One question, two questions. Okay, let's begin in the order you logged in. Let me start with, you are showing up as anonymous, as blocked ID. You could be on a voice over IP. Go ahead, please. Go ahead, say hello. If you raised your hand, say hello.
Hello?
Yes, I can hear you.
Hello?
I can hear you, go ahead.
Yeah, Rajesh, I'm fine. So this is the best option you would suggest, in this case, we have to come back before September 2014 because that is the time I have it now.
I want you to go to your congressman's office. Contact your
I
congressman.
did that.
And what did they do
Yes,
then?
I did that.
What did they do then?
They just said that it's still in the under processing. That's it. We didn't get anything. Okay, so they contacted and they got the reply that it's just under processing.
You have to contact them again. I cannot think of any other way that would help you out of this quandary, because a writ of mandamus is in my view, it's a lousy option in most cases. And remember,
So
even
can I,
even in the writ of mandamus, let me explain to you how it works. First, you have to prepare the writ, maybe take a week, 2 weeks. You file the writ. Government has 60 days to respond. 60, 2 months. 9 times out of 10, the government will ask for an extension of 30 days. That brings you to 3 months. By the time this gets heard by the court, you would have lost 5, 6, 7 months anyway. Plus, you would have lost thousands of dollars that go towards the litigation. So, towards the lawyer's fees. You want to do it, you certainly can. I think you are stuck in a very bad situation. One way you could handle it is, look, you are relatively safe. You're worried about your husband. Why don't you have him go outside USA, come back with a new H1? Would that work, or is it 6 years are over?
no, that will work, but
What you can do is, if he finds a job, since he's not subject to the quota, have the new employer apply for H1 premium processing, request the government that his being out of status is a chain of some very unlikely and unfortunate events. It's not his fault or your fault. Can you please give him H1 status within USA? And in any case, keep an eye towards that 180-day deadline. Okay, I think you're too close to it anyway. So he may have to leave, but you can try for status within USA. But I think you're going to have to separate yourself from your husband as far as H1, H4 is concerned. He's going to have to go for his own H1. That's the only obvious choice I see here.
can I come back to A and do again A to C transfer?
I just said that in my view you cannot. Okay?
So, yeah. So usually the security background check, how long it will take?
Nobody can predict that. I have no idea what the problem is. Are you being investigated, or is the company being investigated? So I really don't know.
Okay, sure. Thank you.
Very welcome. Good luck, ma'am. Okay, next question on this and related topics. Florida. Go ahead, Florida. Florida?
Yes.
Yes, go ahead, sir.
Hi,
Yeah, go ahead, please.
Rachid. Rupinder this side. I have only one question regarding the fee structure. You said that if H1B is filed under premium processing, then H4 can be tagged along with that immediately. Is the fee structure remain same or for H4, or it's going to vary?
Sir, the fee structure remains the same. This is a courtesy extended by USCIS to H4 that is filed based upon a pending premium case. So you will not have to pay any more extra fees for the H4.
Okay. All right.
Good luck, sir.
That's what I'm. Thank you so much.
My pleasure. Bye-bye. Okay, so let me go on to the next question. This also is marked as a frequently asked question because I've seen this situation come up quite a number of times as well. So the employer is a consulting company. We are talking about the H1 letter. Employer is a consulting company. I'm working through a vendor. Client has given me a letter. They have specified the name of the vendor, but my employer's name is not mentioned. So the letter says things like it's a long-term project, but it doesn't have any assignment end date. Is it okay to get extension based on this letter, or should I get a vendor letter? You should get a vendor letter also, because you need to connect these things. How are you working at the end client site? Obviously not through the vendor. So the end client says, I know the vendor, and the vendor will say, I know your employer. That's the way it should work. If it says long-term project without an end, I don't know how government is going to work on it. It all depends upon the officer that you hit. They are going to issue an RFE. Okay, so you'll have a second shot. If they come back and say we need something more concrete, you can take it to your client and say, look, they need some kind of a, typically some kind of a time period which is expected. It doesn't have to be committed, but expected for which the project is going to continue. Okay. Second question is, I've completed 4.3 years on my H1B, my I-140 is approved. Since H1B is for 6 years, I wanted to know how many years of extension will I be getting, 1.7 or 3 years? Well, if your I-140 is approved, you should be getting 3 years, even though, see, government is not consistent in these cases. Will they give you the 1.7 years first and then 3 years? I think they'll give you the 3 years. I think so. At least that's been my experience. My H1B is valid till first week of August 2014. Can we initiate the H1B extension process in premium now? Yes, you can. Yes, you can. 6 months ahead of time. So you're already there. All right. Any follow-up questions on this? Please press *5. Any follow-up questions on what I just discussed? Please press *5. All right, no follow-up questions. Let's go on to Sai 1984, H1B transfer versus filing new H1B using previous year's quota. He's holding, or she's holding, Uma is he or she, I'm not sure. I'm holding an H1B visa valid till July 2015. Haven't been to the US. It doesn't matter. In order to be exempt from the quota, you don't actually have to be in USA, nor do you actually have to join the employer. As long as the case was approved, you become exempt from the quota. Okay. So the new employer is saying they cannot file an H1B transfer, they want to file a new H1B. Well, it's the same paperwork, maybe a little bit different fees. The big advantage is that you will not be subject to the quota, so you don't have to wait till October 1st to join the new employer. So, but if they still want to go that way, then they do want to go that way. Your first question is my case eligible to file a new H1B using the previous year's quota? In my view, yes, it is. I believe H1B transfer is just a word often used. It's more or less the same paperwork and documentation as a new H1. That is also correct. The only difference I could see in case if the employee is already in USA, then no need of a new visa. That is correct. Your understanding is correct. What difference does it make between H1B transfer versus filing new H1B? I don't see any advantage in it. I like the idea of using the quota. In other words, using the previous approval to be exempt from the quota. So I think an H1B is not really a transfer, but an H1B exempt from the quota could be used. Okay. Assuming that the new employer has filed for H1B petition and it has got approved, when I appear for consulate interview, if visa is denied, will the existing petition and visa get void automatically? No, it should not. Can I use the existing visa and petition in future? Only if you can prove that the job still exists. One word of caution though. It is standard operating procedure, which often the consulates don't follow, wherein when you go for a visa stamping of any kind, the consulate should first cancel all the existing visas. But 9 times out of 10, they are not doing that. Just keep that in mind. Your last question is, I want to join the new employer only when the H1B is approved and visa is granted. Otherwise, I want to stick to my present employer. No problem. I don't see any issue with it. Okay, let me go on to the next one. The next one is also marked as a frequently asked question. And Parsh wants to know company spin-off and impact on H1B and green card. Currently on H1B, which is good till 2015, I-140 is approved, working for a media company which is spinning off company A, which is becoming company A and company B. So it's basically divesting itself of one part of it. I will be the employee of company B after the spin-off in May with a different employer identification number. What is the impact of this spin-off? Well, on H1B and green card processing. It's a little bit difficult question to answer. Normally, in any corporate takeover, buyout, here is what we look for, or spin-off, here's what we look for. First, the general principles. One, the job remains the same. So the job title, it can become a little bit different. Job description, pretty much the same. Job location, pretty much the same. The employer's business, pretty much the same. If all of this is the same, then you get into the successor in interest territory, where chances are you're not going to be hurt by anything. There are a lot of variations to this theme. For instance, in your case, if the I-140 is already approved, the spin-off will have to file an I-140 amendment, which is like a new I-140. H-1B may be more easily handled, but it depends upon the nature of the transaction. When not the entire company, but only a part of it is being affected by the spin-off or by the takeover, then it becomes a little bit more complicated. Is there a discrete profit center which is being acquired or spun off? I think that's the same law. So, give you an example. Recently we had a case, we were called in for a merger and acquisition transaction where the company was large. It was being operated as profit centers. So the IT profit center maintained its own books in all its own profit loss. It was basically a division. It wasn't a separate corporation. So when they spun that off, we were able to do, it was purchased by our client. When that was done, we were able to maintain all the H1s and green cards without too much difficulty. So it all depends. But the good news is your priority date is always going to be yours. Once the I-140 is approved, your priority date should be yours. One caveat here. Sometimes if the employer stops business, USCIS can go back and revoke the I-140. Does that take away your priority date? I still think your priority date remains unchanged. Okay. So even in the worst case scenario, if you had to do the green card again, which I don't think you would have to, I'm hoping you won't have to, you would still maintain the same priority date of November 2011. Okay. Parsh, if you are on the phone or anybody has a follow-up question on this frequently asked question, please press *5 on your phone. One question. Okay, let's deal with that. New Jersey, go ahead, please.
Hi, Rajesh.
Hello, sir.
Yeah, it's question number 7.
Number 7. Oh. Number 7. Okay. I wish you had done it at that point when I asked for it, but anyhow, I'll do the best I can for you. Go ahead.
Yeah, so I just wanted to know if the client is not mentioning the end date, right? There is a high chances of getting an RFP, right? So my question is, if suppose a vendor is going to specify, 3 years of my project here, still I will be getting an RFP in this case?
In my opinion, yes, because a vendor's letter does not have much meaning unless the vendor has a contract or a work order that covers 3 years.
Work order, but suppose he has given me the letter and it shows 3 years of project, right? Still it's not going to work?
No, not unless there is a contract with the end client, between the vendor and the end client, or some kind of a commitment between the vendor and the end client that covers 3 years.
Okay.
Now remember,
client is not providing me the date,
I understand. Remember, I'm just making an educated guess. The government is full of surprises, good and bad. Sometimes they'll approve these cases without looking at it twice. At other times, they'll get very persnickety, very finicky about every little detail. So, but going by statistical possibilities, you are going to get an RFE.
Sundarji, what you said?
I think statistically speaking, you are going to get an RFE.
Okay. RFE, okay.
And RFE doesn't bother us. RFE is a fact of life. That's okay. It shouldn't bother you either.
So, what kind kind of documentation is required to respond that RFP? Means like some kind of documentation is required, additional documentation?
It can be. I mean, I really don't know. This is something that it's like asking a doctor to diagnose a patient without even looking at the patient. It can be all kinds of different situations, but typically they want to be assured that there is at least an expectation of continuity for 3 years.
Okay, okay. All right, all right.
Okay?
Thank you so much.
You're welcome. Good luck, sir.
Yes.
Okay. Let's go on to now. I think John J, who's the next person. I think he's posted the same question several times, trying to make sure it's the same person. Maybe not. Somebody has posted the same question 2 or 3 times, and our team, they don't look for duplication. They just close the door close the discussion thread after a certain number of times and a certain number of postings. Okay, so let's see which is the next question. We just finished this. John J says, my I-130 is approved, but my I-485 was denied. What happened was the visa number was not available. Okay, you cannot file a 485 unless the visa number is current for that month. Okay, so if the visa numbers are current in April, you cannot file your 485 one day before April 1st. You cannot. If you do, they will deny your case. And a motion to reopen is not going to help you. Okay. If your lawyer is saying it's their error and you should file an MTR, just make sure there is no error in the dates. If you filed when the dates were not current, nothing you do is going to help you. Okay. The second part about is my spouse's EAD and advance parole denied, or is her current EAD still good? Well, parole is not good. If she tries to travel, she would have a problem. About the EAD, I would agree with your lawyer that unless they go and specifically deny the EAD, and you don't mind being a little bit aggressive with the interpretation of the law, she could continue using her EAD. Because the standard procedure is, excuse me, they should be denying or revoking the EAD separately. Okay, so that part I think I'm okay with. I'm not okay with an MTR if the 485 was filed when the priority date was not current. Now, you are not a citizen. What if your wife accrues unlawful presence and becomes 3 years or 10-year time barred? She cannot get green card because she's barred for 3 or 10 years. There is one exception. If you do become a US citizen and she has not traveled outside USA, even though technically she has overstayed her status for 180 or 366 days, you can still adjust status for her within the United States. So, for spouses of US citizens, unlawful presence does not matter if such spouses have not traveled outside the United States. Okay? That is the law. Then I come to another frequently asked question. I am marking it as a frequently asked question from Rahul 11J. Currently on H1B, so talking about H1B extension beyond 6 years, currently on H1B, first cap counted and 6 years expire on December 6th of this year. PERM was filed a little bit late. The priority date is March 7th. So the PERM is pending with the Department of Labor. Options with respect to H1B extension beyond 6 years based on my understanding are this. Number 1, go out of USA, land before December 6th for required calendar days and come back to US, apply for extension based on PERM filing date plus extra unused H1B period. Correct? But may not be necessary. Let me explain to you something. There was a time before, I think 2005, when USCIS had this interpretation that if you want extension of H-1B beyond 6 years, you must not have any gap between the H-1B original 6 years and the date you file for the extension. So if there's a gap of even 1 day, we will not give you an extension. Then on January 1st of that year, the law was changed. The interpretation became, even if there is a gap in your H1, so let's say you exhaust your H1 for 6 years, in December you leave, you can still come back in March when you become ripe for another H1 extension based upon your PERM filing. So they don't have to run together. However, if you left now and went away for January, February, March, about 3-4 months, you could then combine those 3-4 months, recapture, with your H-1B 7th year extension based upon the PERM filing. There are only 2 ways to get H-1 extension. One is time based. How much time has elapsed? If 1 year has elapsed from the date your PERM was filed, you are entitled to 1 year H-1 extension. Second method is, if your I-140 is approved. We don't care when it was filed, when the PERM was filed. Once the I-140 gets approved, even if the PERM was filed 3 months ago, you are entitled to 3-year H-1 extensions. Okay? So those are the only 2 methods. There is no third method. And of course, recapture of any time outside US. Second option, you say leave USA very close to December 6th, wait until I-140 gets approved. Well, you can file H-1B extension in March when or you can file it earlier than March as long as your start date falls on the date you become eligible. So let me do the math for you. Your priority date is March 7. 6 months before March 7 is approximately October 2013. So that means even now, what am I saying? Give me 1 second. No, I'm sorry. Let me take that back. March of this year. So March of this year you filed it. That means on March 7th, 2015, you are eligible for your 7th year extension. If the I-140 gets approved earlier than that, then you get 3-year extension. So counting 6 months back from March 7th, which is approximately October to April is 6 months. So March to September, yeah. So in September of this year, you can apply for your H-1 extension based upon the fact that as of March 7th, 2015, your labor cert would have been pending for 1 year. So you can apply 6 months ahead. It won't start till March 7th, 2015, but you can file it 6 months ahead. Okay. So then you ask me further, are there any other options other than item 1 and 2? Yeah, sometimes people go to F1 status, get CPT, curricular practical training. I think it's a bad way to go. USCIS does not like CPTs given in the first semester. So stay away from that if you can. Okay. Is item 2 a valid option in the first place? Leave US very close to, well, I explained that option to you. I hope that is clear. In the case of option 1, can I be actively employed with my employer? You can. You can. If you are outside the United States, even if your salary is getting paid in the United States, you're not hurting your H1. Physical presence outside the US is considered to be recapturable time. You can get it back. Even if you're working for the same employer, same job, if you're working outside the US, that time will be recaptured. Same question as item C for option 2 above. With respect to period after December 2014, and where I'm waiting for I-140 approval and subsequent H-1B extension. I'm not sure I understand that. It's a little too complicated for me. Same question as item C, period after December 2014. I think I've explained the 2 options to you. the 1-year extension and the 3-year extension based upon section 106 or 104 of AC21. They should be pretty clear. I hope you're on the phone. I'll be happy to answer further questions. Is there any issue getting my wife's H4 stamp based upon the H1B extension? No. Any gray areas or caveats? If you are going to work outside the United States, make sure your employer discusses that with their CPA, with their accountant, to make sure that whatever salary they pay you or whatever, if they are paying you on 1099, that's okay too. They should do it appropriately. Is there a caveat? Yes, there is one caveat: ability to pay wages. If you are not on the payroll, make sure that the employer has enough money in the tax returns to show that they can still cover your salary. Your lawyers will understand what I just said if you don't. Okay, any follow-up questions on this set of issues I just discussed? Press *5. There was one raised hand, okay? 2 raised hands, all right. Let's start in the order you folks logged in. Wisconsin, go ahead, please.
Hello?
Yes, sir.
Yeah, so I'm the one who asked the question, right? So based on what you just said, I have one question. You said that in October we could file for an H1 extension that comes into effect starting March of 2015.
One correction. September, not October. 6 months ahead of time.
Yeah, so September of 2014 I could file for an extension for like beyond March of 2015, right?
That is correct. Yes, sir.
But then what happens beyond December 6th? Am I leaving the country?
You are either leaving or you're converting to something else like a tourist visa or F1, one of the two. You can't work on those visas, but if you want to work, you'll have to do it outside the United States.
Okay. And then the other option, like the option 2 that I said, is what's basically you go out before December 6th, stay back in your home country, wait till I-140 gets approved, and then come back. So is that reasonable?
Either I-140 gets approved or 1-year anniversary is close by. Yes, that's also reasonable. That's also reasonable. Sure, no problem.
Okay. And then the item B in my question list, it was, so let's say I do this, go back to my home country and wait for I-140 approval and stuff. Can I be like remote working for my employer?
And the answer is yes. You can be working remotely. In fact, that's the better thing to do because it makes the proof of ability to pay wages easier. So yeah, you can do that.
Okay, because basically what me and my employer are trying to work out is somehow try to reduce the number of lost days.
Definitely you can do it, no problem at all.
Okay, and you mentioned some caveat about the tax returns. Could you please repeat that?
Caveat about what? I'm sorry? Tax returns.
Item G. Yeah, you said something about tax returns.
Tax returns. What I said was ability to pay wages. You should talk with your lawyers, have them help you understand that issue. Basically, the employer should have enough money in their tax returns to show that they can continue to pay your salary if you are off the payroll. It's not. Okay. I don't have enough time to go over. That's a fairly complicated issue.
Sure.
I don't have time to do it right here. Talk to your lawyers. They should be able to explain it to you. It's not that complicated for them to explain it to you.
Okay.
Okay.
I think that's all, sir. Thank you so much.
You're welcome. Good luck, sir. Florida, go ahead, please. Florida.
Hi, Rajiv. Thanks for taking my call. My question is not related to this. It's related to answer that you have given. I think you misunderstood. When we filed for my wife's adjustment of status, the dates were current.
Okay.
And we went for...
Go ahead.
And we went for the interview. Interview went really well. And then the same day itself, we got a denial on adjustment of I-485, but we got an approval of I-130. When we spoke to our lawyer, he said that they made a mistake because when we applied, he should have just left the case open instead of denying it. So we made an info pass appointment. And
I got it. Yeah, that makes sense. In that case, so what happened was, when you filed, the dates were current. When you interviewed, the dates were not. In that case, they have to keep the case open. They cannot deny it.
Okay, but here's what happened, Rajiv. We are under the gun because we only have 33 days. So we made an appointment and went for the info pass. And we spoke to the officer there and we explained it to her. And what she did is she had us wait. She went and spoke to the officer and came back and said that we understand we made a mistake. You don't have to file motion to reopen. We will just correct it. Since the dates are not correct, we will reverse the decision and we will send it to the national service place because the dates were not correct. And when we asked if we can get something in writing or can we talk to the officer when they will do, she basically said that we can't really give you anything in writing right now, but I did spoke with the officer and the officer realized that that was a mistake, so he will reopen the case and then you should be fine. However, they have not given us anything in writing, so we are not sure. Should we still, to be on the safer side, file motion to reopen? That alone is going to cost us about $1,700, including the $630 fee. Or since they said that they're going to do that, we took the officer's name, like we know the officer's name who did our interview, and we also know the officer lady who spoke with us when we went for our info pass, who told us, and she gave us her name. So what we should do? Should we just wait or should we file the motion to reopen? That's where we are not sure, even though they did acknowledge that there was a mistake on their side. What would you suggest us if you were our attorney?
I am very conservative. I would rather file the motion to reopen.
Okay. Now let me ask you, if we take a chance and we don't file it, and here comes 33 days and it doesn't happen, we make a follow-up appointment and go and see with them. If we have to file it later on, we have the name of the officer, we have the notes when we went and so. Can we file after that and tell them?
It becomes more complicated because then you are throwing yourself at the mercy of the government to excuse the delay in the filing.
Okay, but even though when lady has specifically stated that we can't give you anything in writing, however, you don't have to do anything, and she assured us not once but 2 times, because she had us wait, and then when we wanted to speak with the officer, she said he's in an interview, so why don't you wait and let me see if I can talk to him. So when the officer got out of his interview, I guess they have an internal messaging system or something. He said that I can't give anything in writing, but I acknowledge that it has been taken care of. And I think she made note on our case itself. And I'm like, what do we do in that case?
My answer does not change.
Can you still suggest that we should file for it?
I don't see any point in taking a chance. It's $1,700 well spent.
So you suggest that we should file for it, and then how long does it take? Well, because the fees itself is outrageously high. Do they refund the fees because it is their mistake?
Actually, they can and they should. In those cases, you can certainly ask for it back, and I think they should refund it. Yes.
Should we just write a letter? So there is a clerical error. I was doing some research that if it's a clerical error, they will not only expedite it, but they will also, because our attorney is suggesting if you file and you don't pay them a fee and you just file, they won't even acknowledge it, or they may, we don't know. But if you file a case, then they have to give you a case number. They have to respond to it.
I definitely think that's the safest thing to do. You can try contacting the customer service and see if they have better suggestions for you. Okay.
So that's what you think. So then, because we still have about 2 weeks left, do you think maybe we should wait a week and see what happens, because it just happened yesterday? So you think maybe wait a week and...
I don't see any harm in waiting another week, but be prepared to file the motion. That's the safest thing. In the meantime, you can also try contacting your congressman's office or even the ombudsman's office. You try doing ombudsman's office, document the fact that that's what they told you, and say, what do you want us to do? We don't want to spend so much money. That way at least you've documented everything, and it probably becomes easier for the case to be reopened in an untimely manner if necessary.
Okay, and how do we file for this optimism that you're suggesting? I mean, can we do it online ourselves?
Yeah, it's just type USCIS Ombudsman, OMBUDSMAN,
Okay.
Ombudsman.
OMBUDSM, okay.
O, M as in Mary, Om, B as in boy, U, D as in doctor, Bud, the letter S as in Sam, and then man as in man, woman, Ombudsman.
Okay, all right, so we will go ahead and do this today, sir, so it's documented, and maybe wait for a week and take a chance, I guess.
Please
Then to just spend, because it's just one of those things that we do. If we file it, he would have done what he needed to do. If we don't file it, then we are just waiting. So it's just one of those things, I guess maybe we can at least wait a week and see what happens and document through ombudsman or whatever you were saying.
Ombudsman. Yeah, I'm sorry, I have to move on. I'm already way out of time and I've got a bunch of questions to cover. Okay? So,
No
yeah.
problem. Thank you so much for taking this.
You're welcome. Good luck, sir.
Thank you, sir. Thank you.
You're welcome. Bye-bye. Okay, guys, I'm going to have to hustle a little bit. Out of USA for many years. Okay. This is a little bit complicated fact pattern. Husband resigns from his job, and husband and wife leave USA in mid-2007, a few weeks after fingerprinting. Husband starts a new job in India. Wife is a homemaker. Husband gets his green card end of 2007, which is valid till end 2017. Wife's green card gets lost in the mail. After a year of correspondence, she does get it. Okay. Husband visits USA at least once every year. That is not grounds for maintaining your green card, but you have a re-entry permit, that is good. Wife's brother got diagnosed with cancer, got his treatment done in wife's house, died in March 2009. Then wife got a really bad attack of rheumatoid arthritis 1 week later and bedridden for more than a year. Okay. Now, husband has been trying to get a new job in USA since 2010, but the market is tight. Wife has not visited USA since 2007. Wife would like to travel in summer 2014. The goal is to re-enter USA and re-establish her permanent resident status. I'm sorry, I don't think it's going to work. First of all, I don't think she's going to be able to buy a ticket because airline is required to check whether she's been outside USA for a year or more. So that I think is not going to happen. You can try contacting the consulate and asking for an SB1. S as in Sam, B as in boy, Arabic numeral 1. SB1 visa, also called returning resident permit. But they want to be convinced almost of every day beyond 1 year why you were outside. Bank accounts, credit cards, none of that matters. Tax returns do not matter. Okay? Children being citizens does not matter. I personally don't think it's going to work. I'm sorry. I think even your green card could be in trouble. So, not much I can say here. Next question is SK 2008, need help on usage of EAD. So, he's been working with his green card employer for 6 years on H-1B, got his EAD in 2012. Now he's got a better offer from another employer with the same skills and same line of work responsibilities. Is it safe to use EAD? Yeah, I think so. I mean, I prefer H-1B. And you said H-1B will be invalid. No, you can always reinstate it. You can apply for H-1B, get it, and then go get visa stamping. You're back on H-1B. What is the process for using EAD? You just present your EAD to the new employer. They'll create an I-9, which is an internal document. Does the future employer have to file AC-21? That's your responsibility. You can file AC-21 and you should. Old company will cancel my H-1B. What about I-140? Is it mandatory to cancel I-140? It is not. But they should, because it's the better practice for employers to cancel the I-140s for many reasons, which I cannot get into. It's not required, but it should be done. If they cancel I-140, will there be any issues down the line for my green card? You should do an AC-21. Another question not related to above but AC-21. The company has sponsored my green card application. I got EAD in 2012. My employer has two companies. After filing 180 days of filing my 485 application, he shifted me. So you went from company A to company B, but you did AC-21. Even if you didn't file it, it's not a problem. I don't think it's going to be an issue. Okay. What would be my status after filing AC-21? Same as it is before. AOS pending. After filing AC-21, will my H-1B still valid? Yeah, H-1B is still valid if you're working on the H-1B. Filing AC-21 does not take away your H-1B. Since the I-140 filed company is closed, is there any problem to my 485 application? It should not be. Okay, because I'm going to have to rush through this. We have a bunch of questions still pending. I don't think I'm going to be able to do any new questions. I hate to be in that situation, but already, I have spent a lot of time. I was expecting it to be done in 1 hour, but it turned out the discussion was a lot longer. So no new questions. I can only do the questions that have been posted, and that too will probably take me a lot longer than an hour, which we had budgeted. Okay. In the next 2 months, I will get my citizenship. Is it okay to file I-130 for my mother without having naturalization certificate? No, you cannot. You cannot. You can only do it once you've got your citizenship. Okay. Next question. This is another frequently asked question. Unpaid leave on H-1B. It's a frequently asked question. I've seen it come up quite often. Normally, unpaid leave does not help you maintain status. It does not. But where there's a genuine reason, it might. I'll give you an example. We have a well-known, a close friend who got into a situation where she was sick for almost 1 year, hospitalized much of the time. We were able to convert her from H1 to H4 even after 1 year of not having worked, on being unpaid leave of absence. So where there's a good reason, you could do unpaid leave of absence, but that is not a good method of maintaining your H1. In this case, the one that is presented here from Manish, entered USA on 7th February 2014, reported to the employer on 10th Feb with a leave of request in hand. 2 reasons: down with fever and cold, did not go to doctor, treated myself. I think that's okay. Secondly, I had to find an apartment to settle. I think these are personal reasons, genuine personal reasons. Question is, how long did you not join? I applied for leave till 28th February. They did not pay me. I think you're okay. I think you have a valid reason and they are trying to accommodate you. I think you should be okay. I'm not worried about it. If you are, in any case, the employer also has a 40, is it 45? Or is it 30 day? There's some grace period when an employee is coming from outside USA. I want to say it's 30, 60. I think it's 30 days. So even 30 days, even the employer is allowed, and the regulations are a little complicated. But the bottom line is this: I don't think 30 to 45 days in these kind of circumstances would be a big deal. Okay. Now, the project client for whom I had to start work from 10th Feb delayed the joining to 18th March after coming to know about my leave plans. So I'll start working on 18th March. I think that's okay. I think that's okay. But there is one part here. Once you are willing to join the employer and you make yourself available, they have to start paying you even if they don't have a project. Just keep that in mind. Any follow-up questions on this, guys? No new questions, follow-up questions on what I talked. Press star 5. 1. Okay. 2. Let's start with Cliffside, New Jersey. Cliffside, New Jersey. Go ahead.
Hi, Rajiv.
Yes,
This is
sir.
Manish.
Yes, sir. Manishi, I can hear
Rajiv,
you.
I joined the employer on 10th of Feb itself, and then I went on leave. So they are not paying me. They are not ready to pay me. They say that you do not have any unpaid leave. So if I do not have any paid leaves with me and I'm on leave and they are not paying me, am I out of status?
I just answered that, and the answer is no. You are not out of status if the leave was for your personal necessity.
And would any documentation would be required later on if they give me an RFT when I transfer my H1 or something of that sort?
I don't think so, because what documentation can you give? You had a case of cold, you treated yourself, you were looking for an apartment. What else can you do? I think you'll be okay.
Okay, and 7th of Feb till 18th of March. So I start working on 19th of March. I come back from leave on 1st of March. My client starts the project on 19th of March. So they will not pay me only for the duration I accumulate hours with my client. So that would be 18th
Hang on,
till 30th.
hang on. That still does not affect your status. I think you should be okay. But you will have a claim against the employer for the weeks that you were ready to work, but the end client was not ready. That's your employer's problem, not yours. They have to pay you. Once you report for duty, they have to pay you.
Okay.
Okay?
Yes. Thank you very much, Rajiti. And this is my fourth interaction. So I landed back in the US after all your help for the last 1 year. Thank you so much for that.
It's a pleasure and a delight, Bhai Sahab. Thank you. Okay. There's another question in this. This is also New Jersey, Boonton, New Jersey. Go ahead, please.
Hi, Rajiv. This is for the question number 13. Need the help on the EAD. My employer, she shifted me from A to B, even though he's the owner for the A and B. That time we did not file the AC-21.
You don't have to file AC-21. I understand. You don't have to file AC-21. It's not required.
Okay. If I move to company C, now the company C has to file from A to B and to AC-21?
No. Just one AC-21.
Oh, one AC-21 is fine.
Yeah, absolutely. Okay.
Okay, great. Thanks for that.
You're welcome. Good luck, sir. Okay. Next one is also marked as a frequently asked question from Man Kumar. H1B filed by a Desi company for an internal project. I traveled to USA for this project, but the client sponsoring the project scrapped the project. Now, current situation is H1B was filed for internal project. LCA had location of this company. Got another project, employer, vendor, client. I have to start working at the client place. Mere LCA amendment or filing is not enough. In a nutshell, the current thinking of USCIS is this. Whenever there is a change in the job, you always have to file an H1B amendment, not just an LCA. The only exception is if the change in job is merely a change in location within normal commuting distance of a location already approved for the same employer or end client. Let me explain. Your end client is IBM. You are working in Manhattan, New York. LCA is approved. If you move from Manhattan to 20 miles away, I don't know what is 20 miles from Manhattan, whatever, in that same commuting distance, working still for the same end client with the same job, no change, LCA amendment is sufficient. If in the same building you go from IBM to Sun Microsystems, your end client changes, you have to file an H1B amendment. Here, an H1B amendment must be done. It is the responsibility of the employer to file an H1B amendment, not your responsibility. Shall I start working for the client once I get the receipt of the LCA filing? I don't think you should. Will you be breaking the law? Yes. Are you going to be in trouble? Status wise, yes, but your employer will be in bigger trouble. So even though the responsibility is theirs, they are putting you in a difficult situation. Feel free to play this file for them. In my view, they could have a lot of problem if somebody complained to the USCIS that they have this practice. The company could be in a lot of trouble. Okay? Any questions on this? Press star 5. Star 5. Any questions? All right. Oh, there are 2 questions. Okay, in the order that you logged in. Cliffside, New Jersey. Go ahead, please.
Hi, Rajesh. So this is Manish again, and this is for my wife. This is happening to my wife. So now employer is delaying H-1B amendment, thinking that they need to make sure that she settles in the job, and then they will file for H-1B amendment.
Yeah,
and if it is a short-term project, they would not file for H-1B amendment, is what they are telling us.
That's not the right way to do things. I think she'll be better off converting to H4 under you rather than dealing with this nonsense.
But she has an employment contract which says that she has to work for that company for 1 year, at least 1 year.
I am not a lawyer admitted in New York, nor have I seen the contract. But as a general matter, no contract can impose upon you a condition to break the law. Any contract that imposes upon you a condition to break the law is void. That part of it will not be enforceable. But you have any doubts, talk to a local lawyer.
Sure. Thank you, sir.
You're welcome. Good luck. Somebody from a blocked phone number, could be a voice over IP. Go ahead, please say hello.
Same client, but the building location change within 1 mile, plus still do have need to file LCA.
Same client, billing location changes. What do you mean by billing location, ma'am?
Then they just moved from one building to other.
Oh, no problem. If it is the same client, same job, no difference in the job title, job description, salary, etc., LCA amendment is all that is needed.
LCA, even though it's within 1 mile.
1 mile is no problem. Normal commuting distance is 30, 40, 50 miles. It's no problem.
Okay.
Good luck, ma'am.
Thank you.
Bye-bye. Okay. Doubts related to green card holder applying for I-130 and having plans for I-131, having plans for future naturalization. I have actually a fairly lengthy video on this. I would like you to watch it. Okay. Basically, I think you need to understand you might have the option of filing N-470 also. Okay. So look at the I-131 N-470 video. If you cannot find it, send me an email to help@immigration.com. I'll have somebody from my office send you a copy of that video or a link to that video. It should be on my blogs. You can look in the blogs. You'll be able to find it quite easily. I-131 N-470. Okay. I don't want to address these issues because I've already done it so many times. Review it. If you're not clear about something, we can talk again in a couple of weeks. I can see that you're not in a hurry right now. I have green card through employment for close to 2.5 years, still working for the same employer, planning to apply for re-entry permit and getting an internal transfer. Because it's internal transfer, you might be able to get N-470. Coming back to USA after setting up my family back in India within 6 months. But there's a chance I may not be able to. So 131 should be filed. Can I quit my job in India and take up a new job to travel within 6 months period? But you could do all of that, then N-470 would not be available. That protects your naturalization. Should I use the I-131 even if I can come back in less than 6 months? I think you should. Will there be any question about this I-131 during naturalization process? Not a problem. My family will be staying in India and may visit USA once in a year with an approved I-131. Will there be an issue for my naturalization? My only concern is the fact that you have quit your job and taken a new job in India, remember I-131 is not a 100% guarantee against losing your green card. Okay? So you could still lose your green card if you have completely demonstrated the intention not to stay here. You may need a one-on-one consultation. This is not an easy situation to cover in a community conference call. I would suggest talk to a lawyer. Also, see my video. I think I've covered most of the ground there. Okay. Next question is Sunil or Kimi. Short summary of what if. I apply for employer change from A to B. Wife goes to India and gets stamped based upon employer A. Then when she's coming back, I've left employer A but not joined employer B. That's okay. As long as you've not lost status, can she travel to on the date above? I think so. Which H1 should she use if asked? The one that is already approved and in place. She can present both H1s. They normally don't ask for H1. They just ask for the H4. Any special documentation? I guess the receipt of the second H1. I personally don't think this is going to be a problem. It's one of those questions that's not really covered by any particular law, but I think you should be okay in this situation. She should be able to travel back on H4. Next question, H1 to H4, change of status, I-539. Currently working on H1B through a staffing company. My project is going to come to an end in March. Looking for a new project. How long can I wait to find my project in case my employer withdraws H1B? Not even 1 day. Can I file change of status via e-file myself? Yes. Please state your attorney's fees. I think you can do it yourself. I have a blog entry on this about getting laid off and applying for tourist visa to maintain status. Read up on that. It contains all the information that you need, including what information you have to provide in the cover letter that you write to the government for change of status. And it also covers your question number 2. So again, I'm going to have to skip this, guys, because I am kind of way over my time. I'm trying my best, but we've spent about an hour and a half, half an hour more than I had budgeted, and I have other things to take care of. So next question is PR to US citizenship questions. Indian national married to a green card holder, I-130 has been approved. My spouse got his green card through family-based immigration 5 years ago. The rule for getting the green card says 30 months stay in USA, which she has qualified, more than 5 years of getting the PR, which she qualifies, but she's made more than 2 trips, each more than 6 months, because of her education. I think she'll be okay. She can apply for naturalization if she has a good explanation for the trips. So I'm not concerned about this situation. Just make sure, maybe a good idea to have a quick consultation with a lawyer to make sure that her particular situation does not have any other facts that create a problem for her, Samir. But in general, when the trip is for a particular reason and not because she's abandoned her green card, she should be okay for the naturalization. Okay? Second question is also from Samir. Third question is also from Samir. I remember that there were some multiple questions. Then B. Shilpa came to USA on L2 visa in May 2012. Before that, I was working with USA company from India since 2007. It's kind of a work from home. Since November 2013, I'm on H1 with the same USA company via change of status. Planning to visit India in coming May. Employer does not have any objection. How many days? He's allowing me to work from India and he'll generate pay stubs here in USA. How many days can I stay in India? So your question is, I'm on H1B and I want to work from India. Can I do it? The answer is yes. And all the time that you're outside USA will not be counted towards your H1. I need to go for visa stamping interview along with my son. Generally, what documents will I need from the employer to for the interview process to be smooth? Read up on the consulate website. They'll tell you what to bring. Generally speaking, you have to show that the job still exists. Okay. Next question. That's typically done through a letter and an explanation. How come they're allowing you to work from India? B Harish 81. H1B denied, specialty occupation. My wife got her employer is preparing an MTR appeal. So basically, it was a quota H1, got denied because they said MBA is not in a specific field. It looks like a bad denial based upon what you have told me. I see no problem in filing an MTR/appeal. Can the same employer or a different employer file a fresh H1B in this quota? Different employer, definitely. Same employer, I'm not sure. I'd have to look up the law. Okay. I think my guess is they can. Is it going to delay when the appeal is pending? If it's through a different employer, there's no delay. Same employer, there could be a delay if it's the same case being filed. So they can say, until the appeal is decided, we'll hold off on the second filing if the second filing is allowed for the same employer. If they do that, then you can always withdraw the appeal. Okay. Earlier denial should not affect the new case through the different employer or the same employer. I think you should do both. The denial looks bad to me. It does not look like a good denial. But I haven't looked at the paperwork. Generally speaking, when the denial is bad, an appeal is a good idea. Okay. Then the next question again is from Samir. Next question is again from Samir. Good. So, guys, I'm done with all the questions for today. But I feel terrible about letting people down. I think I'm going to spend another few minutes. Anybody has any questions, press *5. I'm going to spend a few minutes and try to answer them. 1, 2, 1, 2. Good. 3. Okay. 4 questions. Okay. I'm going to try to answer all of them. Let's make them quick. I don't want to rush you, but at the same time, I do have people waiting for me for other things that I need to do in the office. Okay. So let's start. No more. 4 is all I will answer. So no other questions after that. Okay. Cambridge, Massachusetts. Go ahead, please.
Yeah. Hi, Rajiv. I'm Harish. I raised this question, the last one. Basically, just what I want to ask was, I know being an MBA and a business analyst for 9 years now, and the job applied is also suiting me. Even though the denial is actually not just, what would be the area from which I can argue better? Meaning the specialty application as well, the H1B rules states only a requirement for minimum basic degree, but it doesn't state that it should be in a computer-related discipline. So what should be the best, my best foot forward when I'm arguing?
That's something I cannot answer. I have to look at the whole case. You want to set up a call for a consultation, I'll be happy to take a look at it. But I cannot give you an opinion without knowing what the issues are.
Okay.
Okay?
Okay. I would like to...
Yeah, just send me an email. Send me an email to help@immigration.com. I'll have somebody from my office contact you, okay?
Okay.
Good luck, sir. You're welcome. Bye-bye. Yes, some things I just can't answer without looking at the paperwork. General questions I can certainly answer. Florida, go ahead, please. Florida.
Hey, Rajiv.
Yeah.
Here again.
Yes, sir.
One small understanding I would like to take, actually. What is the actual validity of I-94? Which is tagged with I-797? That is the latest one we can think, even though the older one are expired.
Well, in case you got your status within the United States, it is the I-94 that is attached to the 797 that would govern your status. So normally the most recent I-94, normally.
So the 797, what we have from the current employer, and whatever the duration that has, that the I-94 which is tagged with that 797 is the latest I-94, right?
That would be normally the latest, yes.
Okay, no matter like it has been the older one has been expired or in the visa in the past.
Oh, then we don't care. We don't care as long as you have one existing I-94 and you're following your status on that I-94, the old I-94 has expired is no problem.
Okay, that's what my question was. I got my answer. Thank you so much.
Good luck, sir. Okay, 2 more questions. Let's rush through them. Brockton, Massachusetts. Go ahead, please.
Hello.
Yes, sir.
Thank you for taking this call, Mr. Rajiv.
Sure.
And this is regarding the question number 17, that I-131 and the naturalization doubts.
Sure.
I hear that you mentioned about your video, right? I actually checked out that video and it was really, it is helpful for me. And after saying that, I come to some kind of, with myself, analysis and conclusion that I may not be able to go for an M470 because my employer is not going to support, minimum.
Okay. Then you can do an I-131, and whatever questions you had posted, I did answer them. Do you have anything follow up? Go ahead, please.
Yeah, one quick question is, as you mentioned that my spouse might be taking a job in India and that might be a problem for her green card, but I'm ready to take that also, chance, because assuming that I might be getting my naturalization without any trouble, even though they have, stayed in India for, almost 2+ years, maybe they will be visiting all this, considering this part. Since I have been maintaining my status and no breakage in the more than 6 months, all these facts, considering that if I could able to get my naturalization, I may bring them back whenever required, by applying another GC or.
Sure. That option exists, definitely.
Right. Okay. So I'm just going with the least priority and just want to check on that. Great. So I hear that, yes. So thank you.
You're welcome. Good luck.
Thank you.
Okay, guys, last question of the day from Wisconsin. Wisconsin, go ahead, please.
Hello, sir. This is regarding question 11, post number 11 that I posted. You answered me almost everything. Just one quick final question. This is regarding H-1B extension beyond 6 years.
Right.
You said that I could apply for an extension somewhere in October for that starts in March 2015 and then leave the country in December, based on my current I-94. I heard that they say that you shouldn't be grounding out when something like an extension thingy is pending.
The short answer is, if you travel, this is a question that will take a few minutes to explain, but as applied to you, it's quite simple. If you traveled, all you have to do is go get a visa stamping and come back, and that takes care of everything.
Okay.
So don't worry about it.
Right?
Don't worry about it. That does not affect you.
Okay.
All right.
Thank you so much.
You're welcome, guys. Thank you, guys. Thank you so much for all of you for being here. I'll see you in a couple of weeks. Okay. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.